Welcome to this interview with Judge Christopher Greenwood. Judge Greenwood serves as a judge at the International Court of Justice. Before joining the court in 2009, Judge Greenwood was a professor of international law at the London School of Economics, and he was also a lawyer who, among other things, represented and advised states. It's an honor to have this opportunity to speak today with Judge Greenwood about his experiences at the court. Thank you, Judge Greenwood.
No, it's a great pleasure. Very nice to see you again and very nice to have a chance to chat.
Could you tell us a little bit about what it was like to go through the election process as the British candidate for the ICJ?
Well, I found it quite exhilarating, actually. Of course, a number of my friends who are judges in England were absolutely horrified at the idea that I had an election address and I had to go campaigning, because no English judges are elected. It's not like the position with many of the state judges in America. And they all thought this was quite improper. I actually rather enjoyed it. I think it's important that as a candidate for the International Court of Justice, the World Court, you get to meet the representatives of most of the states, not quite all, but the British government did set up meetings for me with representatives of, I think, about 150 of the states in the UN. And a lot of these are bilateral meetings. They take place in the United Nations building, and it's a chance for the candidate to explain what qualifications they have, what they would wish to do as a judge, why they're qualified to be a judge, and for the representative of the state to ask questions about, not about individual cases, that would not be proper, but about how the judicial role is seen, how it's performed. And some of those conversations I found very, very interesting. Once or twice it went wrong. I did get 10 minutes into a conversation with one ambassador before we both discovered we were talking to the wrong person. That happens. And once or twice the conversations were quite amusing, although not ones that I'd wish to disclose. But for the most part, it was actually a very satisfactory process. Of course, waiting for the result is a bit nerve-wracking, but that's true of lots of interviews as well as elections.
I can only imagine. As a practicing lawyer, you appear before the court a number of times. What is it like to now be a judge at the ICJ after having appeared before it as a lawyer?
I enjoy being a judge in a court where I used to be an advocate. The job is a very different one. At one level, with the work of a barrister, when the oral hearings finish, that's it, the case is over for you. You very seldom have anything else to do until you come to take judgment. But in the case of a judge, it's when the oral hearings finish that the work really starts. And then you've got to write a judgment or write the note on the case, as we do here. But I think there are two rather more important fundamental differences. The first is that as a barrister, you don't have to decide whether your client's case is right or not. Your job is to argue it effectively. Now, you do have to decide whether a proposition is one that you can honestly put forward. You don't have to agree with it, but is it an arguable case? And you should never make an assertion of fact if you know that not to be true. But you don't have to make up your mind about the rights and wrongs of the case. As a judge, that's precisely what you're there to do. That's the essence of the judicial role, so it's more demanding in that respect. The other big difference is that as a barrister, although I tended to work in a team, there was a very strong sense of individual responsibility. As a judge, I'm one of 15, sometimes one of 17 if we have ad hoc judges as well. And we're trying to produce a collegial judgment. And that's a very different job from the job of writing your own speech and working out how you're going to deliver it. It's also very different from the role of a judge in most common law countries where you'd write your own judgment.
On a related note, the other 14 or 16 judges who you work with at the ICJ come from a range of backgrounds. They come from different legal systems, and they've had different professional paths. Could you tell us a little bit about what it's like to work with judges from such a range of backgrounds?
Oh, it's very enjoyable working with judges from a range of different backgrounds. One of the critical features of a court in pretty well any country is that most of the judges will come from the same professional background. Now, the English press, for example, writes articles about the diversity in the judiciary, by which they mean how many minorities, how many women, how many people who didn't go to Oxford or Cambridge. But they miss the much more important point, which is that all of the judges in, say, the Court of Appeal or the Supreme Court, or nearly all of them, have spent years as advocates before they became judges. So they have a shared understanding of how trials work, what's going on, what a barrister is trying to say, what they're perhaps trying to conceal from you. Now, in our court, that homogeneity of professional background simply isn't there. I've sat with colleagues who've been foreign minister of their own country, who've been ambassadors, who've been professors, legal advisors in government. There's a very different collection of professional backgrounds. And I think that actually has more of an impact than the difference in nationality or the difference in the legal systems that people come from. It is, I think, a strength. It can sometimes produce a bit of difficulty in the sense that I take something for granted and then find that a colleague doesn't. But that's actually not a bad thing, to have your unspoken premises challenged. But it also means we bring a richness to a variety, if you like, to the way we approach a case. I might be sitting there listening to an advocate talking about a point of law and thinking, well, I can understand why he's concentrating on this, because he's trying to get us not to look at that. And a colleague sitting next to me is thinking, well, he's wrong about how Security Council resolutions are drafted, because I used to draft them, and that's not how they're put together. And I think that's, especially in a world court, that's very important.
Now, oral hearings at the ICJ are a public event. Members of the public can watch online or in the public gallery, and after the hearings are over, they can look at the transcripts online. What do the judges do after the hearings are over? What happens then?
Oh, I don't think I dare say what we do when we get out of the court. Usually there's a scramble for the coffee. Let me make two comments about oral hearings. The first is that if you go to one of our oral hearings, it will seem very sedate by comparison with a hearing in the Supreme Court in the US or the UK, because you don't have the constant interruptions from the bench. My wife sometimes says that, having spent years as a barrister being interrupted by English judges and consoling myself with the thought that one day I might be a judge and be able to persecute counsel who were appearing in front of me, I then went and took a job on the one court in the world where you can't do that. But if you look at the mechanics of dealing with a court of 15 or 17 judges, lawyers who are speaking on the record, whose words are preserved for posterity, and are therefore, in a sense, part of the practice of the state for whom they are speaking, I don't think you could have the spontaneous question and answer which English and American courts tend to take for granted, less common in courts in the civil law countries. The other point about our oral hearings is that they are the moment, I think, at which the two parties finally engage with one another's submissions. Written pleadings can very easily be two ships passing in the night. They're usually very carefully measured statements. It's at the oral hearing where you're forced to engage with what the other side is saying. It's one of the things I found interesting as an advocate as well. And for that reason, I think our oral hearings are still very important. And of course, in one type of procedure, provisional measures of protection applications, they are absolutely critical because there isn't anything in writing.
The number of disputes being settled by the court is now significantly higher than it used to be. Could you comment on the court's caseload now as compared with decades past?
Well, yes, I can give you a practical example. In 1977, which was the year when I got my master's degree in international law, well, actually it was a bachelor's in those days, but it's now called a master's, the International Court of Justice had one case on its books. Not long after I graduated, the court decided it didn't have jurisdiction to hear that case. And the volume of the court's reports for that year is 4 pages long. And there is one copy in the library somewhere here in the court. It carries a little legend that this volume contains neither an index nor a table of contents. And underneath it someone has written, nor anything else. And that's the low point in the court's history. And then it picked up substantially, largely because of case law on the law of the sea initially, but on a range of other subjects. And in the years that I've been associated with the court, either as a judge or before that as a barrister, the court has heard cases from every part of the world. It's heard cases from every continent except Antarctica, and it's heard a case about Antarctica. It's had cases between states from the same background, states from very different backgrounds, from very different continents. And I think I'm right in saying that there are now something like 67 to 70 states that have been parties to proceedings at the court. In the Kosovo advisory proceedings alone, we had 43 states and the Kosovo government institutions taking part. So I think it's now living up to its name as the World Court in a way that at one time looked as though it wasn't going to happen.
The ICJ is one of a number of international courts and tribunals capable of settling disputes between states. In your view, has the increasing number of international courts and tribunals altered the court's workload at all?
Well, I think it may have altered it in the sense that if there weren't, for example, the Annex 7 arbitrations and the existence of ITLOS, we would probably have even more law of the sea cases than we have at the moment. But I think it's reflective of a growth in adjudication in international affairs generally. Going back to 1977 again, not only was the court not doing anything in those days, we could fit the whole case law of the European Court of Human Rights into about 2 volumes. There was nothing comparable to the WTO. The GATT jurisprudence was much more restricted. Investment treaty arbitration was practically unknown. ICSID had been around for a decade, but nobody was making any use of it. There were very few interstate arbitrations. This time last year, I think there were 9 interstate arbitrations in progress. This court has a caseload as large as it's ever had. Strasbourg has some 130,000 cases awaiting decision, or it did when I last looked. There's much more adjudication than there used to be. Now, it's become fashionable to worry about whether this is leading to fragmentation. But I don't think the signs of fragmentation are there. If you look at the cases that are held up as examples of 2 international courts taking a different view, there are very few real examples of that. Usually there's either a material difference between the jurisdiction of the courts concerned or the legal issues presented to them, or it comes down to those 1 or 2 examples like the difference over state responsibility for non-state actors. This court taking one view in the Nicaragua case, the ICTY appeals chamber taking a different view in Tadic, and then this court reaffirming its Nicaragua position in Bosnia-Serbia. Why is that quoted in all the articles? Because it's virtually the only example. I can quote you many more examples where you don't have fragmentation. Take the case law on continental shelf delimitation. The Annex 7 arbitrations, the ITLOS decision on the subject, our own judgments, they cite one another. They're very much following the same line. Our judgment in Germany and Italy on sovereign immunity and human rights has been followed by the European Court of Human Rights in the Jones and the United Kingdom case. I think the evidence of homogeneity is much stronger, unity, if you like, rather than homogeneity, is much stronger than the evidence for fragmentation.
Most cases at the court tend to take a few years, and some have even taken as long as about a decade. How would you explain the length of the cases at the ICJ?
I think it depends very much on what the case is about. I don't think you should ever expect cases in this court to be dealt with in a matter of a few months. Remember that it's a court of both first and last instance. It's dealing with matters that have an intergenerational effect. A loss by a state in respect of a boundary is going to affect generations yet unborn. And it's therefore right that these matters are pleaded out carefully and that enough time is given for them. That said, I'm very much in favour of our streamlining our procedures wherever possible, so as to make sure that we are not responsible for additional delay. But in many of the cases that are put forward as examples of bad delays, those delays have been the product of states requesting additional time, states requesting 2 rounds of written pleading rather than 1, making preliminary objections, which adds an extra phase to the case. Now, I don't excuse us where we are responsible for a delay, and I think it's important that we try very hard not to do that. But you also have to understand that, of course, we can only handle a certain amount of work at any one time. And if we have several cases that all come ready for a hearing at the same time, we've got to take them one after the other.
The ICJ has a relatively long history, dating back to 1946, and many highly regarded international lawyers have served on the court. Is there a lawyer from the past who you admire in particular who has served on the court?
There are many. I'm very conscious of especially if you think of my predecessors as judges of British nationality, I'm very conscious that I'm sort of trying to walk in the footprints of giants. My immediate predecessor, Rosalind Higgins, was an outstanding judge, first woman judge on the court, president of the court, a reformer. Earlier than that, you had people like Robbie Jennings, who was my professor when I was an undergraduate, Sir Herschel Lauterpacht, one of the greatest thinkers on international law in the 20th century, as well as a very great judge. Arnold McNair, Lord McNair, outstanding jurist. Gerald Fitzmaurice, Humphrey Waldock. They're all men, one case a woman, whom I admire enormously. And there are many judges from other backgrounds too. So I don't think I'd single out any one person in particular, although I must confess to having a soft spot for Lord McNair, partly because as an undergraduate he was president of the Cambridge Union Society, and I followed in his footsteps in that some 75 years later, so I've always been particularly fond of McNair for that reason alone.
Thank you very much, Judge Greenwood, for talking to us today about your experiences as a judge at the International Court of Justice. This takes us to the conclusion of Module 2 on the International Court of Justice. Please join us for the next module on arbitration.